Good morning, everyone. Today, we are organizing the session on basics of drafting skills, which will be taken up by Dr. Nityanand Singh, who is a member of Honorable Supreme Court of India and a fellow member of the Institute of Company Secretary of India. He has also secured doctorate in law. Mr. Singh is an advocate by profession and practicing at Honorable Supreme Court of India. He has extensive experience of more than 20 years in litigation. Dr. Nityanand Singh is a partner and founder of an international law firm, namely Nux and Partners. Nux and Partners has been operating as a corporate firm in retail concept and currently handling litigation matters in more than 500 districts of India. Dr. Nityanand Singh is also running an NGO with the name and style Vidya Vijay Foundation and serving the poor and needy people for upliftment of their education, social and living standard. The name Vidya and Vijay came from the name of the parents of Mr. Singh. The first word is the name of his mother, Mrs. Vidyadhari Devi, and father, Dr. Vijay Narayan Singh. Mr. Singh is a visiting faculty of IIM, ICSI, ICAI, and various other law colleges and business schools in India. Mr. Singh is also socially and politically active and contested the elections of Legislative Assembly at Delhi twice. Now, I would like to invite Dr. Nityanand Singh to continue with the session.
Thank you, Ms. Komal. Good morning, friends. All are here and I'm audible to all of you? Probably yes?
Yes, sir. Yes, sir.
Okay.
Yeah.
The theme is today that the basics of the drafting skills, because I would like to focus on this topic because most of the law students are the person who coming into the profession, maybe CA, CS or ICWA. Drafting is the one of the main thing where the entire case depends. Because once your drafting skill will be excellent, certainly once you will appear before the court and court will go through whatever the draft and certainly you will get a favorable order. So that is one of the most important part. Either you may be appearing in the tribunal, either may be appearing in the court or anywhere. So especially the professionals like CA, CS or ICWA are an advocate. Drafting skill is one of the most important thing which is required. Then we will start with how, suppose, first of all, we will start with the meetings of the clients because we are appearing on behalf of the clients. And what is the requirement of the client, we have to understand first in the very careful manner. Once your client approach you, being a professional, what are documents are required? Because first of all, you have to understand what is his problem and how it can be addressed. Kindly mute all of you, please, requested. And what is his requirement and what the relief he sought and what he wants from you. Because being a professional, it is our primary duty and responsibility to protect our client. Therefore, it may be always in your mind that whoever client is approaching you, he may be right, he may be wrong, but it is our duty to protect him. How we can protect him? It is not our duty to judge who is right, who is wrong. It is the duty of the honorable judges to judge who is right, who is wrong. So first of all, we will try to understand what is the problem. Then we will ask, these are the documents. Then you should make a brief note. If there is a certain problems, then what are the documents are required? Then we will ask our client that please provide certain documents. Suppose if you are taking an example of the person who has invested in money in the real estate business. I am taking an example, you maybe take another examples. Maybe some persons who come, who wants a divorce, or may person some comes who wants to incorporate a company. If any person may come who want to redress their grievances, income tax has raised certain amount against which he want to go for the appellate tribunal or tribunal. So maybe problem may be anything. We have to understand first the problem that I am dealing with, taking the example of the person who has invested in money in the real estate business. And he approached us and said, so that, sir, this is our problem. We have invested approximately 45 lakhs or approximately 1 crore of the rupees. And we have invested this amount in 2010, 2011, 2012, whatever the year may be. And the builder has promised me that he will handed over the possession in 3 years, but even after 4, 5 or 6 years, 7 years has been elapsed, and we are not getting anything, neither we are getting the refund, nor getting the possession. Then it should be come in the mind that which section or which act is applicable, where you have to approach, which court you have to approach. It may be Consumer Forum, maybe RERA, or maybe the civil recovery. There are the 3 options are open. Or if there are the number of the persons are more, then you can go to the NCLT. These 3-4 options are available. It should be very clear in your mind what are the options are available. Then it is our primary responsibility to look into what are the documents are required. Suppose if the person has invested the money, then I am taking this example and I will explain the entire thing on this example. Then first of all, we will ask the document that when you have registered, when you approach the builder, what is amount you have invested, what is your allotment letter, what is the agreement to sell, what is the demand raised by the builders, and what the amount you have paid, and what is the receipt, where is the receipt, how much amount you have paid, entire amount paid through cash or entire amount paid through bank transfer, or you have availed the loan facility, then what is amount of the loan, and from which bank you have taken the loan, and till today what is the status of the project. You should provide certain photographs of the project. Apart from that, if there is any conveyance deed executed, not executed, or any other documents like is there any environmental clearance, is there any licenses has been obtained by the builders, or is there occupancy certificate, or there is a completion certificate has been obtained. All those documents are basically required to know how you can proceed with. Once you will ask all these documents from the client, in the same manner, if the client wants their another grievances, then you can ask the same questions and you can ask another documents, which is very relevant. Note down all those documents, what are the documents are required. Then you should ask all those documents. Once he has provided all those documents, then you should arrange all those documents in the chronological manner. That is also a very important part, because I am going to touch only on those issues which are creating a difficulty while you start drafting. And before drafting, what the preparation you should, then this is a very important thing. Once all those documents you have received, then you should prepare all those documents in a chronological manner. Chronological manner in the sense, what is the first document, then second document, means date wise. Suppose you are invested in money in the 2011. So first of all, you should go for the letter, that the very first letter given by the builder. Then you should, there is the allotment letter, then you should arrange those allotment letter. Then you have paid the amount, then there is a receipt. Then you should place that receipt. Thereafter, there is an agreement to sell or a buyer builder agreement. Then that agreement. And if there is any demand has been raised in the date wise, then you should arrange all those documents date wise. And if there is any possession letter offered, then you should chronologically arrange all those documents, because all those documents are very necessary. So thank you, dear. So once the document has been arranged, then once the document has been arranged, then you should start drafting. And once you should start the drafting, you should first of all prepare a brief note. In your first para, what is the brief? And if there is any requirement to ask, yes, please tell me how much amount you have invested, what is the date, and all those things. If there is anything required to ask, you should consult your client and you should ask your client, these documents and these information are required. Please provide the information. Once all those information are gathered, then you should start a drafting. My suggestion is that before going to file a complaint, you should draft a legal notice. That is a very basic thing. And you should cover all those points. Once you started the drafting of the legal notice, then the very basic thing is required that in the very first thing you should write, it may be delivered through courier or speed post or WhatsApp or email. This is the very first line on the letterhead. And once you are sending the legal notice, it has to be on the letterhead. Second thing, that date. Sometimes I observe and receive the notices which doesn't mention the date. That is not a legally good. You should mention the date very clearly. That date is mentioned. Thereafter, you have to look into who may be the party to whom you want to serve the notice. It may be the director of the company, it may be the company, or any other persons who are dealing with you. Because in the most of the time, the people make a mistake. The professionals make a mistake that who should be the party to whom you want to serve a notice. Then it should be very clear that once you are entering into the agreement with the company, then the first of all, company has to have a party. Because sometimes I receive the notice and feel that suppose I am dealing with the person, marketing people, or any CFO, CEO, or manager of marketing. Then person make a party to the marketing manager and serve the notice to the marketing manager or CEO, CFO. This is a wrong practice. You should not do like this. You cannot serve to the notice of the employee, because employee is not responsible for any acts and deeds done on behalf of the company. You are entering into the agreement with the company, then you should make a party either to the company or to the director of the company. So it should be very clear in the mind. This is the very first thing, you are addressing to whom. And once you are addressing to the company, then you should also go and visit to the MCA site. Then what is the address of the company? That is the registered office of the company. I request Vivo Y21T, please mute, because there is some disturbances. Please mute. Sorry. Then once you are making a party, you should be very, very careful to whom you are serving the notice. And while you are serving the notice, nowadays there is a prevalent practice that you should also mention the email ID and mobile number. Because there is a prevalent practice that you can serve the notice through email as well as on the WhatsApp. Sometimes it may be possible that once you are serving through speed post or courier, maybe the company address is not there, maybe it may be returned. But once you are serving through WhatsApp or email, certainly it will be served. And email ID provided on the MCA website. On the first of all, you have to serve on the registered address of the company as well as the corporate office. If you are only serving on the corporate office, then there may be some problem. But always the company have maintain their registered office. Then if it is the case of the company, then 100% you should visit to the MCA site and take an registered office address. Email ID is there. Maybe mobile number is not there, but email ID and address is there. The list of the directors is there, and list of directors and his address is also there. So this is one of the things that you have to keep in the mind. Then come on the second point, that is the legal notice. You should draft in the subject. What is the subject? For which purpose you are serving the notice? This should be very clearly mentioned that you are serving the notice either for the recovery of the amount, you want a refund, or you want a possession. Then you should write very clearly that legal notice for recovery of amount of so and so along with the interest, or legal notice for possession of the flat bearing number so and so, so and so. This is the second point. Then you should go on the body of the legal notice. The first of all, you should mention that what the builder is doing. Suppose he is in the real estate business. So first of all, explain yourself that what are you doing? Suppose my client is a professional, our client is doing the business. So first of all, the first para that my client, and you should also mention the address of the client as well. First of all, the address to whom you are serving, and second, our client, name and address, email ID and telephone number. Once it is written, then you have to write that under instruction form on behalf of my client, you are serving this notice. Then you explain yourself, what are you doing? Suppose I am the businessman, then you should write my client is a businessman and running their business from so and so places. Then what the builder is doing, then you are doing the business so and so. Then you will come on the what is the contents, what is the issue, what is the facts of the case. Facts of the case in the sense that I have booked this flat in so and so dated, entered into the registered agreement, builder buyer agreement, and you have paid certain amount and you have given the receipt. The column of the amount you have paid, receipt number, that should be the very in the clear demarcated. That suppose once you are paid the amount in 2001, date, receipt, and amount and total consideration. This should be clearly column wise, it should be mentioned. And what is the amount you have paid, that is in the last, you have clearly conspicuously mentioned that this amount has been paid, because this is the main issue of the entire legal notice, what the amount you have paid. Thereafter, you have to retain that there is an agreement, and in this agreement, as per the clause, what is the clause of the possession, that you have to mention in this legal notice. I am taking an example, that's why I'm explaining all those things. You have to go through the agreement and you have to very clearly mention that as per this agreement, as per clause so and so, you have is clearly and specifically stated in your agreement or builder buyer agreement that you have to hand over the possession within that particular time, but you did not hand over the possession. Therefore, I am entitled for refund of my amount. It should be very clearly mentioned, because relevant para are necessary to be mentioned on that particular legal notice. Once you have mentioned this, then you will come on the last para, that what the law is being violated. Either once you are going for the deficiency in service, then you have to mention that even after receiving so and so amount, and even after a lapse of 4, 5, 6, 7 years, and as per the committed, this is 3 years you have to give the possession, but even after 6 years has been elapsed, you have not handed over the possessions. Therefore, there is a clear-cut deficiency in service on your part. Hence, you are liable to refund my amount. And in the last para, that should be also very clear that this amount you are, hence, therefore, you are liable to refund my amount. Amount is very clearly in the word as well as in the figure, both, because this last para is a very important. You should not make a spelling mistakes. You should, in words, you should also put it in words as well as in the figure. Very clear that this amount is, I am asking for the refund. You should pay that amount. And once you will not pay that amount within that particular time is also mentioned. It may be 7 days, 10 days, 15 days, a month. There is no specific pro forma that it has to be refunded within that particular period, especially in this case. But there are the certain other statutes in which there is a certain specific time is mentioned that you have to refund that amount in this particular period. But in this particular case, there is no particular time is mentioned. But yes, you can simply say, you can refund my amount within a week, within 10 days, or within 15 days, or within a month. Whatever suits to you. Normally, standards that you should refund my amount within 15 days from the date of the receiving of notice. Otherwise, you will consent to initiate appropriate legal action against you. And in the last, you should write your name very clearly, Mr. So-and-so, advocate, and you should also write your enrollment number. And once you write your enrollment number, always careful that while you are serving the notice, it should be properly signed by an advocate. Whoever name is written in that particular legal notice, it should be signed. Sometimes my experience shows that the person served the notice but forget to sign it. It may be the mistakes of the clerk, maybe the mistakes of the juniors, maybe the mistake of the anyone, but it doesn't matter. And once you are serving the notice without signing, then there is no value in the eyes of law. The opposite party can raise a question that whatever the legal notice served, it has not been properly signed, therefore there is no value in the eyes of law. So it should be properly signed. Always keep in mind each and everything. At the very minute details I am explaining what should be done. And if anything is mistaken or anything is lapsed or anything is forgotten, then it is a very difficult situation. You will be in the hot soup. So very clear, very conscious. Once you are doing anything, it should be very consciously and doing very clearly. There should be no any spelling mistakes. And once you are drafting, started the drafting, there should be the double spacing, or not maybe double spacing, but it should be very neat and clean. It should be properly marginal, left side margin, right side margin, and it should be in the very clear and proper manner, so that once the people can read it very carefully without any spelling mistakes and very clear, so that it can be easily readable. Otherwise, that is a difficult situation, because in the normal parlance, you can say this legal notice is a beautiful love letter. Really, because once you are going to send someone, once you will keep in mind that you are going to write a letter to your beautiful loved one, so certainly you will be very cautious. So you should always keep in mind that whatever you are going to write, that should be, and of course, once you are writing a letter to someone, your loved one, it should be very precise, not should be very lengthy. Suppose if it is 5-10 pages, then it is very difficult to read one. Of course. So you should be very precise, concise, to the point, and you should also cover all those things. Your entire sentiments should be included in this. So once you are started drafting the legal notice, you should always keep in mind that you are going to write someone who is your loved one. So it should be the very, very precise, very conclusive, and whatever you want to convey, it has to be conveyed. Therefore, you should be very cautious. Once your legal notice has been drafted, then you should be properly post it. It may be either courier, maybe registered daily. And once you are also be very cautious while you are posting it, because once your love letter go to someone else to whom you want to serve, it had not been go to that particular person, that it is very difficult situation. You can understand. You want to serve someone else and it goes to someone else. What will happen? You can imagine. So whatever the address you are writing on the envelope, for the lighter mode, don't take otherwise. Once you are writing the address on the envelope, that should be very accurate. And to whom you want to serve, it has to go to that particular person, not to someone else. So once you want to send someone letter to someone, and probably it goes to his father or someone else, so it is very difficult situation. You can understand what will happen. In the same manner here, you should address in the very careful manner. Otherwise, once you will serve the notice, it will not be served, then it is very difficult to file a case. So address very carefully. Sometimes some persons write a wrong address. It's my personal feeling, personal experience, that sometimes we suppose if it is address is 26/182, but wrongly it is mentioned 26/181. Then what will happen? It will not serve to the concerned person. It will return. Then whatever the purpose to serve, that has been defeated. So you should be very cautious. You should also write an email address. You should also write the mobile number, so that if the person is not reaching that particular place, then he can call to that person and he can serve the notice. Serving of notice is also a very important thing. And once you have served the notice, then you should take a, you can say, take a delivery report. Delivery report is also very, very important. Once the letter has not been delivered, then you cannot file a case, because sometimes you will file a case, then certainly court will ask you whether it has been delivered or not delivered. Especially once you, I am talking about one section 138 NIA. If your check is dishonored and you are serving the notice, then the 15 days time has to be mentioned in your notice. The check number should be very properly mentioned. Amount will be properly mentioned. Once there is a mistake in the check number, then your legal notice become illegal and you will never win the case. And your case will be dismissed on this issue as well. And you have to also mention in the legal notice that please refund that amount within 15 days, because there is a statutory time period has been mentioned in that particular section 138 of NI Act. So I want to tell you that every act has a different, you can say, different procedures, different time limits. So while you are serving, you should be gone through that particular act, what particular act is saying, within how much time it has to be served. Once you are going for the operational creditor or financial creditor, there is a serving of the notice, there is always a time period mentioned. Once you are serving to the operational creditor, there is a time period mentioned. Then you have to mention that time period, that yes, within 10 days, 15 days, whatever the time is mentioned, you can go through the act. But I am only talking about the practical difficulties. What the practical difficulty is being faced once you are drafting the notice. Once it is delivered, and even after delivery of your legal notice, the person is not refunding your amount, then you can approach to the court for the redressal of your client grievances. Before approaching to the court, legal notice part is over. Now we will come how to draft a complaint and how to approach to the court. So first of all, you have to decide which court is the appropriate jurisdiction. Jurisdiction is the very, very, very important point. And before you started the drafting, you should very careful about the jurisdictions where your case will lie. It may be district forum, it may be, because I am taking an example of the builder and buyer. Therefore, it may be district forum, it may be state commission, maybe national commission, maybe RERA, or maybe NCLT. These all are the forums are open for the buyers to redress their grievances, or may go to the civil court. Normally, in this matter, I never advise to go to the civil court, because once you are going to the civil court, it will certainly take a time 7 years, 8 years. And once you are nowadays, they are very, very fast recovery in the RERA, that is especially designed act for the real estate project. So once there is a grievances against the builders, then you should approach to the RERA first, or the consumer forum, because consumer forum is also taking some more time, maybe 3-4 years. So RERA is the fastest remedy available, because in the RERA, there is only once you have filed a case, there is no procedure for the admission hearing. Certainly, it will be served to the notice to the opposite party, giving the direction that you have to file the reply. Once the reply has been filed, it is matter is fixed for the rejoinder, or straightway you can go for the argument. So there is no procedure for the leading the evidence, cross-examination, and all those things. And once you are going for the consumer forum, then of course it is also a speedy redressal, but it takes more time than the RERA, because it also serves the notice. Then the opposite party come, file the reply, then rejoinder. Then there is a procedure for in the consumer forum, the evidence. Evidence has to be filed by both the parties, then the written arguments. But in the RERA, there is no procedure for the evidence. Just file the reply, address the argument, over. And in the most of the cases, the real estate is very kind enough to the consumers or buyers, and they are refunding the amount in the most of the cases. And once the project has been completed, then the RERA is also compelling to the buyers that yes, you should take the possessions because the project has been completed, he cannot refund the amount. So this is the entire story of the complaint. But yes, we are talking about the jurisdiction, where you should go. Before going to the jurisdiction issue, and you should keep in mind that you should go through the agreement. Builder-buyer agreement is a very important document for deciding the jurisdiction. Once go through the agreement, and if there is an arbitration clause, in most of the agreements, there is an arbitration clause. Once there is an arbitration clause, if it favors you, it is also very important. If it is a 50 pages, 50, if it is a 50 pages document, and most of the cases, this document favors to the builders. So then once you are appearing on behalf of the builder, then you should think about the builder. And once you are appearing on behalf of the client, the buyer, then you should think about the buyer. Once we are appearing on behalf of the buyer, then you have to look into what is the jurisdiction, what is the clause of the jurisdictions, because once you have put your signature on the builder-buyer agreement, then you are bound by all those clauses, terms and conditions of that builder-buyer agreement. Then you should be very cautious. You should advise your client in the very cautious manner, because once you will not advise properly, and once you will file your case without having the jurisdictions, the fate is the very, very bad. Because after 4-5 years, you will feel that this consumer fora or this RERA didn't have a jurisdictions, and your complaint will be dismissed on this issue that this court didn't have a jurisdictions. So it is a very, very, very bad that after 4-5 years, you will feel that this fora didn't have a jurisdictions. What the reaction would be of your client, you can imagine. So if you should be very cautious, because once you are sending the letter to someone and it goes and delivered to someone else, you can imagine other people will read those letters, then what would be the impression is, you can imagine. In the same manner, here you have to think over that you should not file a case where there is no jurisdiction. The jurisdiction issue has to be decided first. You should go through the jurisdiction clause. Sometimes in the agreement, it is very clearly mentioned that this court of Delhi or court of Bombay or court of Jaipur has exclusive jurisdiction to entertain the disputes arising between the parties. So before going to file a case, you should read very carefully the jurisdiction clause. What the jurisdiction clause is saying. It may be Delhi, it may be either Delhi, Bombay, or wherever. But if there is a word exclusive, if there is a word exclusive being used, then you cannot file a case any other else except in that particular jurisdiction. So you should be very cautious. And if there is an arbitration clause, and in the most of the cases, arbitration clause, jurisdiction is mentioned in the agreement. Once there is an arbitration clause, then you have to read the clause very carefully, and you should invoke the jurisdiction. If you should invoke the arbitration, if it favors you. If it not favors you, then you should not invoke it. Once you are the builder, then you should invoke it, because there is a special clause in the arbitration that whoever will be the arbitrator will be appointed by the builder. Once there is arbitrator appointed by the builder, certainly you can feel so that yes, you are going to get a favorable order. So it has to be decided. It may be going in your favor, or it may go against you. Once you are going against you, that you should not invoke. Apart from that, you should also consider the pecuniary jurisdiction. Once you are talking about the cases of the consumer forum, then there is a pecuniary jurisdiction also. Once the price of the flat, total price of the flat is more than rupees 50 lakh. Suppose if the cost of the flat is 70 lakhs and you have paid only 10 lakhs or 5 lakhs, even though you have to approach to the forum which has jurisdiction, forum or commission which has jurisdiction more than rupees 50 lakh. In the recent scenario, the jurisdiction of the district commission, now it has been changed, Consumer Protection Act 2019. And as per the Consumer Protection Act 2019, there is a district commission, state commission, national commission. That this jurisdiction, pecuniary jurisdiction, because there are the two types of the jurisdictions, that is the pecuniary jurisdiction and territorial jurisdictions. Once you are talking about the pecuniary jurisdictions and your total flat of the price is 50 lakh or less than 50 lakh, then you should approach to the district commission. If it is more than 50 lakhs and up to rupees 2 crores, then you should approach to the state commission. And if it is more than 2 crores, then you should directly approach to the national commission. The state commission and national commission has original jurisdiction as well as the appellate jurisdiction. So this is a very, very important point, that your letter should be delivered to whom, and it has always to be delivered to the concerned person, not to someone else. So this is very important point, jurisdiction issue. And second issue, before drafting, you should also consider the cause of action arises, because in every act there is a certain time period prescribed, either maybe 2 years or maybe the 3 years. Once you are talking about the consumer cases, then it is always a 2 years. 2 years from the date of the cause of action arises. Cause of action arises, you can also say that the default occurs. Once you are approaching to the NCLT, then in that case, when the default occurs. Once there is a default occurs, then it has to be within 3 years from the default occurs. And in the consumer cases, cause of action arises when the default occurs. A cause of action arises within 2 years from the date of the cause of action arises. Once you are talking about the section 138 NI Act, then check has been dishonored, then within 1 month from the date of the dishonor of the check, you have to serve the notice. Then within 45 days, you have to approach to the court. Once the 45 days is over, you have gone. So you have to be very particular about the timings. Two issues are very important. First of all is the jurisdiction issue. Second is cause of action. So before you started drafting, you should always keep in mind. And once you have to keep in mind, then you will proceed further. Now I will show how to proceed and how to draft a complaint one by one. I'm sharing. Kindly see. Once you are approaching to the commission, maybe district commission, maybe national commission, maybe the state commission, according to pecuniary jurisdictions and territorial jurisdictions. Once you are talking about the territorial jurisdiction, then in the consumer fora, every act has their own jurisdiction. How the jurisdiction will be decided, it is always prescribed in the act. As per the Consumer Protection Act 2019, where you can file a case in the territorial jurisdiction, we have already explained the pecuniary jurisdiction. In the territorial jurisdiction, where the opposite party resides, opposite party means buyer, builder, where the opposite party resides, opposite party career in the business, or directors or other persons resides, or cause of action arises. There are the three jurisdictions. The opposite party resides or carries their business. The cause of action arises, or the opposite party carry their business. And the fourth point, which has been included after the amendment of Consumer Protection Act 2019, that where the consumer resides. This is most important. Adding insertion of this particular thing, it is a very relevant for the consumers and very convenience for the consumers, that wherever the consumer resides, he can file their case in that particular place. Suppose I am residing at Bangalore and booked the flat in the Gurgaon, then I can file a case in the Bangalore itself, need not to come to the Gurgaon. But once you are talking about the CPC, civil procedure, then this clause is not given, that where in the civil nature cases, wherever the defendant resides or defendant carry on the business, or cause of action arises. So this is the advantage under Consumer Protection Act 2019, that wherever the consumer resides or wherever the aggrieved person resides, they can file the case at that particular place. There is no such facility available in any other act. Once you are talking about the section 138 NI Act, then the jurisdiction lies where the principal place of the branch where you have opened the account. So we have to look into all those facts. So first of all, once you will start the drafting, then you should write like this, that to whom, to where you are approaching, maybe state, maybe national commission. Then what is your consumer complaint number? This should be in 2023. Once you are filing the case in 23, then you have to write 23. And then the name of the party. What is the name of the party? It may be, suppose I am filing Nityanand Singh, and suppose if there is a booking in my name as in the name of my wife, then the name of both person has to be included in the complaint, Mr. Nityanand Singh and Mrs. So-and-so. Then the title would be Mr. Nityanand Singh and another. If there is a booking in the name of the three persons, then the title would be Mr. Nityanand Singh and not another, others, ORS, others. If the person is two persons, then Nityanand Singh and other. If the person is more than two persons, then Nityanand Singh and others. And you have to write here, that is complainants. Then the opposite party. If you are making a party to the company only, then it is only opposite party. And once you are making the party to the company as well as directors of the company, then it is the opposite parties. But you have to decide whether the directors of the party should be the party or not. In the most of the cases, company is independent entity, can be sued. Therefore, it is my advice that you should not make a party to the directors, because in the case of the company, directors are not personally liable. So you should avoid these, because once you will make a party, certainly the opposite party will come and they will raise a question, they will file the application that these names should be removed. Certainly it is unnecessary wastage of time. So you should avoid all those things. And second thing came into, that is the brief synopsis. Before you started drafting, you should draft a brief synopsis. What is the entire case is? And brief synopsis means it is one pager only, not in the 5-10 pages. Brief synopsis means one pager only. That suppose I have booked a flat so-and-so year, I have paid so-and-so amount, and even after paying so-and-so amount, he has promised to deliver the possession within 3 years, but he has not delivered the possession 3 years, even after serving the notice. Therefore, you are approaching to this honorable court for redressal of my grievances, for refund of the amount. That's all. Brief synopsis will be very clear and conspicuous, not more than the 1 pages, or maybe 2 pages, but not more than that. Because the honorable judges who are going to read your brief synopsis, it should be clearly understand in a very short manner, because you can understand the honorable judge doesn't have much more time to read all those things. He has very limited resources, limited time, and judicial time is very important. And once you are an advocate, it is the art of the drafting, that your draft should be in such a manner that the honorable judges can read hardly within 2-3 minutes, and they can understand, yes, this is the case. And once you have written 10 pages and even he is not able to understand what we have written, that there is no relevancy at all. Suppose मैं उदाहरण देता हूँ कि अगर कोई थाली में अगर जो है दाल, चावल, रोटी, सब्जी, एक ही थाली में अगर आप जो है तो प्लेट में, जैसे आजकल शादियों में होता है, एक ही प्लेट में सब कुछ भर के आ जाता है, तो इट डजंट लुक्स गुड और खाने में भी दिक्कत होती है। लेकिन अगर जो है एक थाली में छोटी छोटी कटोरी में जो है सब कुछ रखा हुआ है, एक चम्मच रखा हुआ है, तो किसी को खाने में बहुत सुविधा होती है। तो जैसे आपको उस खाने में सुविधा होती है, उसी तरह से आपको एक थाली परोस के जज साहब के सामने देना है कि जज साहब को जरा सी भी दिक्कत ना हो, और ही कैन इजिली एक चम्मच उठाए और सीधे जो है मुंह में आ जाए। तो योर ड्राफ्टिंग शुड बी सच ए मैनर दैट the honorable judges don't waste their precious time. They can go through hardly 2-3 minutes and easily understand what the council wants. Because in the most of the time you have appeared before the Honorable Supreme Court and hardly say 2-3 lines and immediately notice. I would like to make clear that once you are appearing before the Honorable Supreme Court, it is very difficult to get a notice from the Honorable Supreme Court. And once you are appearing, your drafting skills should be such excellent that yes, once you are appearing, say something and immediately issue notice. Then it is a very great achievement to get a notice from the Honorable Supreme Court. It should be very clear, very conspicuous, concise, precise, but to the point. In the concise and precise, you should not skip anything. Everything should be covered. There should be brief. First of all, you should prepare brief synopsis. Then you will go forward. List of dates and events. This is also a very important thing. You should prepare the list of dates and events. List of dates and events means what happened today, what happened tomorrow, in the chronological manner. Suppose you booked a flight in 2011, then first date, then when we have paid the amount. And suppose if you paid the amount in the 2-3 years, then you should not write all those dates in chronological manner. You should write in the one portion that from 2011 to 2014. From this date to this date, you have paid certain amount. This is the brief. Otherwise, what the people will do? Certainly in 2011 you have paid, then 2000 November 2011 you have paid, December 2011 you have paid, then January 2012 you have paid, June 2012 you have paid, then December 2012 you have paid, in January 2013 you have paid. This should not be done. Unnecessary. It is you are extending your pages, but it gives a negative impression. You should write in one point that from 2011 to 2014 you have paid certain amount. That's all. Therefore, the bill of wire agreement has been executed and so and so dated. These list of dates and events not more than the 2-3 pages, not more than that. We should cover the entire things. Because I am saying again and again that should be precise. Only because of that, it should be not be very lengthy. Once you are writing a letter to some loved one, and it is a very lengthy, then it becomes frustrating. क्या लिख दिया भाई 10 पन्ने में, क्या मैं पढ़ूं? ऐसा नहीं होना चाहिए. आप जो भी लिखना है आप अपने सेंटिमेंट्स अपने एक पेज में ही लिख के दे दीजिए और पढ़ने वाला भी खुश रहेगा. हार्डली टेक्स, ठीक है भाई, बहुत बढ़िया लिखा. अगर आपने उस लेटर को 10 पेज का बना दिया तो वो तो पढ़ते पढ़ते सब छोड़ रहा है, फालतू की चीजें बहुत लिखता है भाई. इन द सेम मैनर हियर इज आल्सो इन द सेम मैनर. आप ऐसी चीजें लिखिए जिससे इट इज वेरी इजी टू रीड. ऐसा नहीं कि 10 पेज फालतू लिख दिया. नो. Synopsis, list of dates and events. Then you come on the memo of the party. That is also a very important issue. Once the memo of party to whom you want to make a party, if it is not a relevant party, and if it is not within that particular jurisdiction, then it is a very difficult issue. You should make a memo of party. Suppose it is booked by 2 husband and wife, then you should make a party to the complainant, husband and wife, both. Not only one, both. Because in sometimes I also personally feel that the person who is not very acquainted with the drafting, he has approached to the commission because it's not required that every advocate should appear before the consumer commission. Anyone can appear. Even if you want to go personally, you can appear in person. So suppose if certain times it's drafted, they will make a party to the only one person, not another person, then that complaint is being rejected. It is not in proper manner. So once there is a complainants and opposite party, then you have to make a opposite party in the very taking into consideration the jurisdiction issue. Either maybe territorial, either maybe the pecuniary. So all these things you should be remember. You should never make a mistake. क्योंकि चिट्ठी उसी को जानी चाहिए जिसको आप भेजना चाहते हैं. दूसरे को गया समझिए गड़बड़ है. And then you will come forward and then you will mention the complaint under section so and so of the Consumer Protection Act. This is also very important point, that under which provisions you are approaching to the commission. It is under which section you are approaching to the commission. That section should be also the relevant section. Once it is under section 12 or under section 13 and you are writing under section 21, then it is also a wrong one and your complaint may be dismissed. So once you are mentioning the section, it should be very relevant. Otherwise, you can skip section as well. But once you are writing the section, it should be very, very accurate. If any section, it is consumer is under section 12, you are filing a complaint under section 12, then it has to be 12. It cannot be 13. So it should be very cautious. You should be always, it should be always 12, not 13. Then what the complainant is doing, you should mention. And thereafter, what the opposite party is doing, you should also mention that opposite party is doing so and so, so and so. Thereafter, you will come on the brief facts of the case. You should elaborate all those points in the brief facts. You have booked so and so amount, so and so dated. You have entered into the agreement, and you have paid certain amount. And what is the clause in the mention? Suppose if it is mentioned in the flat buyer agreement that you have to give the possession on that particular time period, then you have to specifically mention that thing. That is very important, and you have to cover all those things. In the what is the wrong as per the agreement? He has not committed. He has not fulfilled their commitment as per the agreement. Then you should also mention, and what are the amount you have paid, that has to be mentioned. And whatever you are mentioning, and you should mark that document as an annexure. Suppose if you are filing a case on behalf of the company, then there should be a mandatory requirement that it has to be filed to the board decision. You have to file a board decision, then and then only it can be signed by you. Suppose if you are filing through a company and someone has signed on behalf of the company, and they have now placed on record that board decision who is authorizing on behalf of the company, then your entire petition will become infructuous. So I am only touching on that issue where that legally it means you should be legally sound, and you should annex all those documents. Otherwise, your petition becomes infructuous. It will be dismissed. Once you do a very hard work, entire hard work, 2, 3, 4 years fighting a cases from pillar to post, and at the end you will find that due to some technical reason your case is dismissed. It is very, 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 you can say, very, very bad. You can say you can't imagine what you will feel after 4, 5 years when case is dismissed only on this ground that you have not placed on record the board decision. Then it is very pathetic situations, and you are not able to explain your client. And once your client will ask how my case has been dismissed, then you will say, yes, I didn't place on record the board decision, that's why it has been dismissed. How you can imagine? It is very pathetic. So always keep in mind the very, very small issues, and that is not only very small but very important issues. You should always keep in mind. Then all those documents you should annex through annexures. And once all those documents have been annexed, then you will come on the law point. You have to also research which law is being violated. Suppose if it is in the case, it is a deficiency in service, cheating, fraud, or deficiency in service. Once there is an unfair trade practice or deficiency in service, then you should specifically mention that you have promised, you have committed to deliver the possession of the flat within 3 years, but you have not delivered the possession within 3 years. Therefore, there is a clear-cut deficiency in service. Then you should explain what is the deficiency in service, what is the unfair trade practice. You should also explain in your complaint. And once you explain that, then this legal point is covered. And if you want to quote any judgment, suppose any judgment in your favor, if you want to quote in this complaint, you can quote, but not the entire judgment. What is the only relevant para of that judgment? Then you should put it in writing that the para number so and so clearly says, Honorable Supreme Court says on this para, that para so and so, and we are reproducing that para. Hardly it is 3, 4 lines, not more than that. You should not put it in the writing in the complaint the entire judgments. Only the judgments, particular year, judgments number. If it is the Manupatra number or SSC number, then you can mention SSC number so and so, Manupatra number so and so. If it is not mentioned, then you should mention the case number so and so, decided on so and so, and relevant persons. That is very important. And once you have mentioned, then you should come on the issue, that is the cause of action. I am showing the entire body of the complaint because you can easily understand what should be incorporated, what should be not to be incorporated. That is very important. Cause of action: when the cause of action arises, when you have made the last payment, when you have demanded your money, or when you have demanded your possession, then the cause of action are that particular period. In the real estate business, cause of action is continue unless and until he has handed over the possession or refund the amount. It may be 4 years, 5 years, 10 years. Suppose you have booked a flat in 2011, and even in 2022 he has not handed over the possession, then you can file a case. Cause of action is continue in this, because Honorable Supreme Court judgment says so. Cause of action is continue unless and until you have handed over the possession and refund the amount. So you have to be explicitly mentioned, and once you are mentioning the cause of action, then once you have booked the flat in 2011, then you have to mention that cause of action arises when you have booked the flat. Cause of action further arises when we have paid the amount. Cause of action further arises when we have entered into the agreement. Cause of action further arises when the possession letter has been issued. Cause of action further arises when you have served the legal notice, and cause of action is further continue till the amount has been refunded. So this is the language you have to use. Cause of action is continue. Then the question comes further: what is the jurisdiction of this Honorable Commission? How you have invoked this jurisdiction? You have to very, very clearly mention then how you have invoked that jurisdiction. We have already covered the jurisdiction issue. Then what is the requisite court fee? You have to also pay a certain court fee. Once you have not paid the court fee in the proper manner, then it has not been entertained by the honorable judges. Then you have to clearly mention that particular court fee has been paid. Suppose if it is in the case of the consumer, then it may be 2,000, maybe 5,000, maybe 10,000, but it has to be paid. In the cases of consumer forum, hardly 2 to 5,000 in the district commission, or 5 to 10,000 in the state commission. Maybe, I'm not very sure what is the amount, but yes, whatever the amount, as per your amount, you have to pay the court fee. And that is also very, very important. Once you not pay the court fee, then your case is not going to be entertained. And last but not least, that is the issue is the limitation. You have to write that you have filed the case within the limitation, within the 2 years, within 3 years, or whatever the limitation is as per the act. It has to be mentioned in this complaint that yes, this is within that limitation, you have filed the case within the limitation. If any reason, if it is not filed within the limitation, then you have to move an application that yes, it is not within the limitation, there is a delay in filing this complaint, and that application will be entertained first by the honorable judges. Once that your application will be allowed, then the case will continue, otherwise the request may be dismissed. So time is very important in the sense that you should mention that your case is within the time, and you have to do your duty within the time, not after the time, because sometimes it may be possible that your case is dismissed only because that it is not within the time. And the last but not least, that you have not filed any other case or anywhere in any other court. That is the last para, that whatever the complaint is filed before this honorable commission is not filed in any other high court, Supreme Court, or any other court. This has to be mentioned. Once you have filed any other case in any other court, then you have to clearly mention, yes, you have filed this case in this court as well, because the consumer fora or RERA or NCLT, all those are the tribunals, and whatever the remedy available, you can avail your remedy. And last, that is the last para, is the prayer clause. That is a very specific. That is very specific, and you have to be very specific what you want from the court. What you want, you have to be very specific. And I would also like to suggest that this prayer clause should be always on the separate page. It should not mix with the another page. Suppose if your line is here end complaint, then you should not start prayer from this para itself. You should always mention your prayer clause in the separate page, because that is very, very important. Honorable judges always go through that prayer clause in the entire file. That will open the brief synopsis and go for the prayer clause. Then your prayer clause should be very separately mentioned in the separate page, and that should be very clear and conspicuous. That should be very clear what you want. You want to possession, you want to refund, or whatever we want, that you have to clearly mention in your prayer clause. Then in the last, you will come on the verification that Mr. So-and-so, whatever you are saying, that is true and correct as per my best knowledge. And thereafter, and every complaint has to be supported by an affidavit. These affidavits are not on the 10 rupees stamp paper. So never make a mistake like this, especially once you are talking about the consumer complaint. Once you are going to the NCLT, then there is a different procedure. Once you are going to the consumer fora, there is a different procedure. It is not should be on the 10 rupees stamp paper. Once you are going to the NCLT, it may be on the 10 rupees stamp paper, but here not. So and complaint has to always be supported by an affidavit. Once it is without affidavit, there is no value in the eyes of law. Once there are the 2 persons has to file their complaint, then the 2 persons has to file their affidavit. And apart from that, if you are asking for the interlocutory order, suppose you have filed a case and you want to immediately relate, then you have to move an interim application. Interim application in that particular section, that, my lord, once case will continue, it may go for 4 or 5 years. Meanwhile, kindly restrain the builders not to sell this property, or not to dispossess, or not to dispose of that property to someone else. Then immediately you will get a relief on the very first date of hearing. So this interlocutory application you have to move. This application is, and its prayer clause should be also very clear. So, and every applications always be supported by the affidavit. Without affidavit, no application will be entertained. And in last but not least, you should also place on record the wakalatnama. That is also very important. Once you will not file your wakalatnama, then you are no more in the picture. You cannot appear. Then once you are signing the document, you are asking your client, you should also sign prayer clause, affidavit, and wakalatnama. If there is entry applications, that application has to be signed, and that application has to be supported by a proper affidavit. So all those things I try to cover within that particular time, and probably I am able to make it understand to all of you who is the persons listening here. So I would like to conclude that drafting is a very excellent skills, and you have to, once you are going to the profession, then you have to understand what are the basic requirements of the drafting. It has to be precise, to the point, concise, properly marginalized, both right hand side. Kindly see, this is a complaint, and once the complaint is complete, therefore you have to prepare an index as well. And in the index, you have to write court fee, list of dates and events, memo of party, what is the complaint, and what is the application if there is an application. Then all those documents were placed on record, like as Annexure 1, Annexure 2, Annexure 3, Annexure 4, Annexure 5, and at the last, wakalatnama. This index is also important. And it has to be signed. It may be signed by you itself. It's not mandatory that it has to be signed by the client, but you can sign. So all those documents have to properly maintain, like as kindly go through and see. This is the very clearly cut, very clear. It is not very hodgepodge. It is very clear. So once you are drafted, your drafting should be very clear, and it is easily readable. Like a kindly see, you can even it can be easily readable by anyone, and very clear, proper pagination, proper spacing in the 2 paras, and always there should be the different paras. If you want to write something, it should be in the different para, 4 or 5 lines in the 1 para, then another para. You should not write everything in the 1 para. So all those things are very much required, and certainly time is over. Thanks to all of you for the present sharing. If any question answer, then anyone, my learned friend wants to ask any question, so all are the most welcome. You can open now your videos, and kindly so that I can look the faces, beautiful faces as well. So all are our beautiful listeners, so I can see all those faces. Please switch on your videos. And if any question, you are most welcome. Request to switch on all of you your videos, please. Yes, friends. If there is any question, certainly certainly I will answer those questions. If there is query, certainly please ask.
Sir, in case of it is related to delivery of notice, question
Yes.
related to delivery of notice. In case of company, we can deliver the notice into the registered office. But in case of individual, sometimes happens that address is incorrect. So due to which we are unable to send notice to particular individual address, but we have sent on email or WhatsApp. So what we can do in that case?
Yes, certainly. Once there is, sometimes it found that that person is not residing there and he has shifted their residence. Then you can serve the notice through WhatsApp, through email, because if the person is almost every person has their mobile number, and using the mobile nowadays. And once we serve through the WhatsApp, certainly it will be ticked. Once there is a double tick, it will be deemed to be the service. But you have to give an affidavit. Yes, you have served through WhatsApp in the court. That is deemed to be service, because Honorable Supreme Court in the judgment itself says yes, this service will be deemed to be the service to WhatsApp and email as well. In the Corona period itself, judgment was passed.
Okay, sir. Thank you, sir.
Most welcome. If any other question, please. Man Singh ji, if you want to ask certain questions. मान सिंह जी, am I audible?
हाँ जी सर, नमस्कार।
नमस्कार सर।
बहुत बहुत धन्यवाद। बहुत अच्छे से आपने बहुत इजी मैनर में हमें समझाया कि कैसे मतलब कि अपील को फाइल करना होता है। मुझे बहुत ही इजीएस्ट वे में, मैं तो मतलब कि एडवोकेट मतलब कि एलएलबी नहीं कर रखी, लेकिन काफी कुछ नॉलेज आपसे मिला कि आप ये मेरे इनकम टैक्स की या जीएसटी फाइलिंग में भी काफी हेल्पफुल होगी जो आपने बताया मुझे।
जी, आप एक लव लेटर लिखना शुरू कर दीजिए, आपको अपने आप समझ में आ जाएगा।
हाँ जी।
How to draft?
हाँ
It has
जी।
to be very precise and concise.
I think it is important for everyone.
Everyone, yes, everyone. Whoever is the professional.
To the law field or other field.
Maybe in any field, but how to draft, how to say something, how to communicate with the people. Because whatever you are writing, the person who are reading those things, that particular thing, he can imagine which type of the draftsmen are. क्योंकि हम जब कोर्ट में जाते हैं तो कोर्ट में जो है हमें खड़े होने से पहले जज साहब उसकी फाइल को पढ़ लेते हैं। जज साहब को फाइल पढ़ने के बाद ये पता लग जाता है कि कैसे वकील साहब ने इस ड्राफ्ट को किया हुआ है, वो इस चीज को भाप जाते हैं। और इमीडिएटली जैसे समटाइम्स हम कई बार सुप्रीम कोर्ट में अपीयर होते हैं, अपीयर होते से ही हमें जो है कहते हैं यस नोटिस इशू। हमें इतनी खुशी होती है कि हमने इतना अच्छा ड्राफ्ट किया है कि जज साहब को जो है एकदम मुझे ज्यादा बोलने की जरूरत ही नहीं पड़ी।
हाँ जी।
इट इज वेरी इंपॉर्टेंट, वेरी इंपॉर्टेंट। जी। Any other question, please?
Thank you, sir.
There is one addition only, sir, I would like to add.
Please.
When we go in NCLT or NCLT form, right, they need page number also along with annexures, right?
Yes,
to mention the page number also.
Yes. Sorry, मैं भूल गया बताना। बिल्कुल सही कह रहे हैं आप, बिल्कुल सही कह रहे हैं कि हर डॉक्यूमेंट के ऊपर पेज नंबर लिखा रहना चाहिए। बिल्कुल सही है, क्योंकि once you are referring any particular portion, then it has to be mentioned through page number. In this particular page number so and so. Sorry, आपने बहुत अच्छा याद दिलाया, लेकिन हर डॉक्यूमेंट्स में पेज नंबर जरूरी है और इसको मेंशन करना ही चाहिए, क्योंकि बिना पेजिग्नेशन के तो फिर कोई डॉक्यूमेंट पढ़ना पॉसिबल ही नहीं होगा। क्योंकि once you are
in the application also in annexure we have to attach, in the application also we have to mention along with annexures.
Yes. Very right, very true.
Yes. Okay, thank you, sir.
Thank you. Is there anyone, please?
I think everyone has got their queries cleared now. So we would like to conclude today's session. Thank you so much, sir, for providing us the knowledge, for enlightening us about the basics of drafting. It is certainly very important, not just for advocates, but for everyone, the basic things about drafting. Thank you so much, sir.
And we will decide today what our next session would be on the 11th March. Maybe if any of our friends are interested to deliver anything on any topic, maybe it may be GST or whatever the experienced person and who feel that yes, I am expert of that particular field, any of our friend, they can deliver the lecture. Otherwise, we will keep on taking the session, and probably we will decide what would be the session. Certainly we will share in the group, and so that if anyone of us wants to suggest what should be the session, next session. Yes, sir, please मान सिंह बताएं.
सर मैं ये पूछना चाहता हूँ कि क्या YouTube पे भी आपकी ये वीडियो अवेलेबल है क्या?
हाँ जी, बिल्कुल अवेलेबल.
ठीक है सर, इससे तो और लोग भी बेनिफिशियरी होंगे इस चीज.
बिल्कुल होंगे.
ठीक.
So अगर if anyone interested, they can take a session. Otherwise, you will take a session on the RERA.
ठीक.
How to file a complaint before the RERA.
Thank you, sir.
Thank you to all of you for the such a patient hearing. I'm so thankful for your precious time. Thank you. Namaskar.